Assalamualaikum warahmatullahi wabarakatuh. This is part 2 for the Zoom recorded lecture for the topic misrepresentation, continuation of part 1. So in part 1, we have discussed about the first element, which was false statement of facts. And we discussed as well position of silence under common law as well as under Contracts Act. So basically, under Malaysian law, which we refer to Contracts Act 1950. So basically, position in Malaysia, we follow the approach under common law. So second condition, which must be fulfilled in order to have an actionable misrepresentation, is that inducement. It relates to the first element. Okay, it's about false statement of facts, and this false statement of facts must have induced, okay, must have persuaded, must have caused the representee, okay, to enter into the contract. So in other words, okay, whatever statement, okay, the misrepresentation here, it has to be material, it has to be significant, and there is a reliance, okay, on the part of the plaintiff, okay, when the statement was made towards him. And again, we are talking about requirements under English law. So we cannot see this requirement under Contracts Act 1950. But generally, we follow the same approach. Okay, so material here, it means that it has to be very significant. Okay, it has to be very relevant. Okay, in the sense that it would have induced, okay, it would have caused a reasonable person to enter into the contract based on the false statement, okay, which has been false statement of facts which has been made by the representative towards representee. Okay, and significance, okay, material, and it has to be reliant. The statement was the one which caused, okay, the plaintiff to enter into the contract. But what if no reliance? Even though there might be a false statement of facts, but there's no reliance on the part of the misrepresentee. So there will be no actionable misrepresentation. Cannot sue based on misrepresentation. This is what happened in the case of Horsfall and Thomas here. In Horsfall and Thomas, a classic case, common law, 1862, it involves sale and purchase of certain gun. And the buyer of a gun, actually, when he made his decision to buy, okay, he did not examine, okay, prior to purchase. So he would know, okay, whether the gun has some defects or not. Later on, he realized, okay, he discovered about it. So the court held that concealment of a defects here in the gun, okay, it did not affect the decision of the buyer to purchase because he was unaware at all, okay, about the misrepresentation. So, in other words, there's no reliance as far as the, even though there could be concealment of defects here. So the action based on misrepresentation failed. Okay. And then we also have, similar approach, and we have provision which relates to reliance here. Illustration B to section 19. Okay, let's have a look what illustration. So when we talk about misrepresentation, section 17, 18, and 19, they are all related. They are all relevant. Okay, let's have a look at illustration B, section 19. Okay, section 19. Okay, 18. Okay, 19. Okay, this is 19. 19 talk about voidability of agreement. It says something about misrepresentation here. We want to focus on illustration B. Okay, here, example. A, by misrepresentation, okay, A leads B erroneously to believe that 500 gantans of indigo are made annually at A's factory. And B, okay, after hearing whatever statement by A here, B examined, okay, the account of the factory. He made his own checking here. And from the accounts, okay, it shows that only 400 gantans. So it doesn't match, okay, whatever statement made by A here. And after the checking, okay, B decides to buy the factory. So can we say the contract was affected by misrepresentation? No. Okay, the legal ruling is that, okay, the decision of the law is that contract is not avoidable on accounts of A's misrepresentation. So in other words, there's no reliance here, even though it doesn't say so, but basically B did not rely on the whatever statement by A here, because B actually do his own checking, and it's clearly stated in the account that it's only 400, not 500 gantang, as stated by A. Okay, we go back to our slides here. Okay, so meaning that here from illustration B just now, there will be no reliance if the representee does not rely on the misrepresentation, but he actually rely on his own judgment or investigation. So later, okay, when he cannot really withdraw from the contract, okay, he cannot set aside the contract based on misrepresentation. But again, okay, exception to the rule here, if the misrepresentation was fraudulent, there's element of cheating, okay, then we don't apply the rule. I mean, no ruling of own judgment or investigation whatsoever, because at the first place, it involves fraud. So it's a very serious, something serious in nature. So the case is Atwood and Small, and also Weta Constructions, Berhad and Lau Wan Ing. Okay, what happened in Atwood? This is another leading case, okay, which shows, which apply the rule of reliance here. What happened was that Edward and Small, 1838 here, purchaser of a mine, so it's about sale and purchase of a mine, okay, and they were told exaggerated statements, okay, as to its earning capacity by the vendor, because vendor wanted to make sure that the deal is on, okay, that's why he said all those exaggerated statement, all the puffing statement. And then, even though hearing all this exaggerated statement here, purchaser, before they made a decision to buy, okay, had this statement, whatever stated by the vendor, checked by their own expert agent. This agent checking whether it's true or not. But the agent made some error, okay, who in error reported them as, okay, yes, correct, you can proceed with it. But actually, there was an error on the part of the agents here. And then after 6 months, okay, 6 months after the sale was complete, then only plaintiff discovered, wow, your statement was inaccurate. Now they wanted to rescind, okay, set aside the contract on the ground of misrepresentation. But House of Lords held that, that's why the case is important, because it is the decision by House of Lords. House of Lords held that no misrepresentation. Because why? Okay, when the purchaser decided to buy, okay, to proceed with the purchase, they did not rely, he did not rely on the representation, because they have done whatever necessary checking. Okay, if after all it's negligence on the part of their own expert agents. Okay, this is our local case, also on the same issue, similar application of the law, of the rule. So Weta Construction, I think B is Brunei, is it? Companies Berhad and Lau Wan Ing, 1981. So this is a purchase of piece of land, okay, sale and purchase of a land. So plaintiff bought a piece of land from defendant. So defendant is the seller, the vendor. And then plaintiff alleged that he was induced, okay, by the defendant's false representation that the land was near Cebu Airport. So during negotiation, defendant said, well, my land is good, okay, goodbye. It was very, very near to Cebu Airport. And then when the court examined all the facts here, okay, the court found that statement did not mislead the plaintiff, okay, despite it was made by the defendant, the statement here. Because why? Plaintiff had instructed his solicitors to investigate the title, and after all the checking was done, okay, on the land title, it was in consequence, okay, of this investigation that the plaintiff was advised that the Cebu land was a good buy. He did not really rely on the statement made by the defendant, who said, oh, the land was near Cebu Airport. So from the checking, he can see, is it near here? How near is near? Is it 5 kilometers? Is it 10 kilometers away from the airport here? So the court held that, in this case, the plaintiff had trusted his own inquiries and he rested his judgment on his solicitor's advice rather than the false representation made by the defendant. Okay, so you cannot set aside the contract based on misrepresentation. There was no, because the second element was not fulfilled. Okay, another issue which relates to reliance here, okay, what if the party had the chance, he had the opportunity to discover the truth if he has done the checking? Can we say, oh, you cannot follow suit based on misrep because you didn't check? You have the chance to check, but you choose not to check. Can we impose liability on you? Does it affect the right to bring the case under misrepresentation? So under English law, the court said yes, okay, doesn't matter. If you have the chance to check but you didn't check, then you can still file a case based on misrepresentation. So under English law, there will be reliance. Yes, okay, it is considered fulfilled. Even if the misrepresentative is given opportunity to discover the truth, but does not take the offer up. So yes, the second condition is still considered fulfilled. Even though if the plaintiff check it, actually he could discover the truth. He could discover, oh, it was really, I mean, the statement was misleading. Okay, I mean, the statement was untrue. But then under Contracts Act 1950, okay, generally, okay, we are in line, okay. But as far as reliance is concerned, there's little deviations here. I mean, you can see the last bullet there. Under Contracts Act, 1950, our position with regards to opportunity to check, okay, here, the truth, the position is different provided under exception to section 19. Okay, let's go back to section 19, but now we want to focus on the exception. Okay, this is section 19. Section 19. Section 19, it has exception, it has explanation. Now we want to focus on exception. If such consent was caused by misrepresentation or by silence, fraudulent within the meaning of section 17, I mean cross-refer to 17 and 18 actually, the contract nevertheless is not voidable. That's the part. Okay, the contract is not voidable. I mean the contract is valid if the party whose consent was so caused, okay, the victim, the plaintiff, had the means of discovering the truth with ordinary diligence. I mean, if you have the means, if you have the methods of checking the truth, so you have to check. I mean, it will affect your rights later if you decided not to check. Okay, so I mean, the law on this point is slightly different. I mean, we don't follow English law on this part. Yeah. So what is the effect of the section that we read together just now? Okay, so a contract in such a situation is not voidable. I mean, it remains valid, cannot be set aside. So in other words here, okay, even though it doesn't say so, but analysis is that there is a duty, legal duty on the part of misled party, plaintiff, okay, to exercise ordinary diligence. So meaning that here we read together section 17, section 18, okay, together with explanation and exception to section 18. All the three sections actually, they are all related, interrelated. Section 17 will be relevant if there is any elements of fraud. 18 is misrepresentation without any elements of fraud. And this is the case, okay, to illustrate the application of the rule just now. A local case, Tan Chai Chiu and Eastern Mining Metals Company Limited. So what is all about here? Contract was pertaining to assignment of rights. I mean, you can assign your right. I mean, you give your right to somebody else. Okay, assignment of rights to prospect certain mining lands for prospecting permit. And then actually, respondent company here, they had the means, okay? They had the facilities, they had the money, okay, to discover the truth with ordinary diligence, but they simply enter into the contract without checking the true position of the mining land, okay, even though they have all the facilities to do so. So can they set aside the contract later based on misrep? No, okay, the court held that the contract was not voidable on the grounds of misrepresentation. Because of this opportunity to discover the truth, but decided not to take it out. Okay, so it will affect the rights to set aside the contract. But then again, it's very subjective, okay, because we don't know whether the party, we can impose such a duty on the misled party here. So the misled party should act according to the standard of reasonable man in his position. Okay, and then this standard, because subjective, it might vary, might differ according to the circumstances from case to case basis here. And then another rule, okay, under this rule, sub-rule under the rule is that in some situation, okay, exception to section 19 is inapplicable. I mean, the duty to check whatsoever, it won't be relevant. Okay, for example, if the plaintiff does not have the means of discovering the truth, I mean, how can we impose the duty? No means, okay, no facilities, no money to check. So we cannot apply exception to section 19. Meaning here, reliance is considered fulfilled. Okay, in the case of title, boat and cigar or plantation. This is judgment by High Court. What happened? Okay, defendant, the vendor, okay, he knew the existence of the structures, okay, on the land. Okay, what's the structures here? Water pipelines and transmission cable. Okay, and prior to signing the agreement, so he was aware of it. Okay, And then, but there was misrepresentation here. Okay? The misrepresentation was made through an agent to the plaintiff, the purchaser, who deliberately, okay, who were misled and deceived by it. I mean, that exists misrepresentation, and because of the nature, it was done purposely. Okay? So the court held that, well, this is fraud. It is amounted to fraud under Section 17. And then the court also said, no, we cannot apply the assumption just now. Okay, defendant was not allowed to rely on the ground that the plaintiff had means of correction, had means of discovering the truth. Because why? The contract was tainted with, statement was tainted with fraud at the first place, elements of fraud. So we cannot apply the chance to check, okay, the duty to check whatsoever here. Okay, so that's why the court said neither was the exception to Section 19 applicable, because here, as the plaintiff did not have the means, and then here there was elements of fraud, okay, in the statement, which amounts to misrepresentation. This is the case of Tai Tomo. Okay, second situation in which Section 19 won't be applicable. The first one, no means to check the truth. Okay, the second one, false and fraudulent misrepresentation. Okay, whenever it involves false, okay, fraudulent misrep, then we don't apply the opportunity to check. The duty to check on the part of the misled party here. For example, in the case of Weber and Brown, very, very old case, 1908, what happened was that respondent purchased a rubber estate from the appellant. This is an appeal case. And later, he sued the appellant for making false and fraudulent statement about the number of trees. Here, the owner will know the exact number of trees on the estate here. So the court held that provisions of law, exception to Section 19 of Contracts Enactment, okay, before it becomes Contract Act, does not apply to this case. Because why? Okay, the representor in this case had actively made a false and fraudulent statement. It's no longer misrep here, it's fraudulent statement. Okay, because in misrep, the party believe it to be true, even though it's not true. Here, the party does not believe it to be true from the very moment the statement was made. Okay, on top of the two conditions that we have discussed, okay, sometimes in some exception situation, there's also additional condition, okay, which is relevant. Okay, here the condition is that the maker addressed the statement to the party misled, because sometimes the statement was not really addressed to the party misled. So that's why the condition is imposed, but not all situation. Usually the two conditions are sufficient. But sometimes there is also this additional condition wherever it is relevant. So the case is Pick and Gurney. What happened in Pick and Gurney? So the appellant purchased shares, okay, on the faith of the false statement contained in the prospectus. So all the statement was contained in the prospectus, and this prospectus actually was issued by the promoters of the company. But this prospectus was only meant, okay, addressed to the first applicant for shares, the one who buy the shares for the first layer, first applicant, okay, and it's not extended to others. Next buyer, the prospectus is not addressed to them. So appellant's action against the promoter failed, okay, because why? The false statement, okay, even though there was false statement here, it was not addressed to him, okay, because the appellants in this case, the position of appellants here, he only purchased shares from a lottist. If we look further, maybe it is something with regards to probity as well. Okay, the contract is between a lottee and the first applicant. Okay, not really a lottee with directly from the promoters, okay, of the shares, the one who prepared the prospectus. Okay. Despite that exists false statement of facts here. Okay, we stop here. I'll be continuing with the third part, okay, of the topic to discuss about types of misrepresentation. So, stop share. Okay, that's it.